Hello everyone. I welcome all of you to the 23rd session of the course Energy Law. In today's session, we will examine the Energy Charter Treaty's substantive protections. Let us quickly recap what we have covered in the previous session. In the previous session, we have examined the challenges relating to admissibility and jurisdiction. We started by examining the scope of jurisdiction by looking into the aspect of consent of the contracting parties and its limitations. Then we saw the common jurisdictional challenges based on amicable settlement, fork in the road, and denial of benefits. Then we saw who are the investors under the Energy Charter Treaty and what investments are protected under the Energy Charter Treaty. Then we examined the investment protection regime under the Energy Charter Treaty, seeing who are the investors and what investments are protected under the Energy Charter Treaty. In the later part, we examined the recent debates on the applicability of Energy Charter Treaty on intra-EU disputes and the tax carve-outs under the Energy Charter Treaty. In today's session, we will examine the substantive protections under the Energy Charter Treaty, covering fair and equitable treatment, full protection and security, the prohibition against unreasonable and discriminatory measures, the prohibition against unlawful expropriation, and the umbrella clause. Let us examine fair and equitable treatment. Article 10(1) obliges the contracting parties to accord fair and equitable treatment to protected investments. Specifically, it provides that each contracting party shall, in accordance with the provisions of the treaty, encourage and create stable, equitable, favorable, and transparent conditions for investors of other contracting parties to make investments in its area. Such conditions shall include a commitment to accord at all times to investments of investors of other contracting parties fair and equitable treatment. Two common sets of fair and equitable treatment claims that have been brought in the context of the Energy Charter Treaty are failure to provide a stable and transparent regulatory environment in the light of the investors' legitimate expectations, and secondly, denial of justice. Several tribunals have considered the role and relevance of an investor's legitimate expectations at the time of investment in considering the alleged breaches of fair and equitable treatment. In Electra Bell, the tribunal observed that it is widely accepted that the most important function of the fair and equitable treatment standard is the protection of the investor's reasonable and legitimate expectations. To demonstrate that a breach of fair and equitable treatment has arisen from an investor's legitimate expectations, tribunals have considered mainly three aspects. Firstly, whether representations or assurances were given by the host state to the investor at the time of investment. Secondly, whether the investor reasonably relied on these representations and assurances in making the investment. And thirdly, whether the state's conduct was contrary to these representations or assurances. Another major consideration in this context is that of the predictability and reliability of the state's regulatory regime. In this context, the tribunals have also considered the stability and predictability of the host state's regulatory regime. The ECT tribunals have also considered denial of justice as a component of fair and equitable treatment standard. For instance, in Energolians versus Moldova, the tribunal found that Moldova had violated the fair and equitable treatment when the Court of Accounts, a quasi-judicial financial oversight body in Moldova, issued a decree that found, contrary to clear evidence, that the investor had not supplied electricity pursuant to certain contracts and ordered Energolians to return the money allegedly paid to it. Notably, there was no evidence that Energolians had ever been paid. The tribunal observed that the decree amounted to a denial of justice and breach of Moldova's obligations under Article 10(1) of the Energy Charter Treaty. Let us examine the standard of full protection and security. Article 10(1) requires a contracting party to accord the most constant protection and security to an investor's investment. ECT tribunals have observed that a key component of this standard is an obligation of due diligence, which requires a state to create a framework that provides security and protects the property of aliens from wrongful injury or harassment. ECT tribunals have recognized the potential for constant protection and security protection, often referred to as full protection and security protection, to extend beyond physical security and include legal security. Tribunals considering alleged breaches of full protection and security have confirmed that this obligation does not impose strict liability on the state to prevent all injury. Let us examine the prohibition against unreasonable and discriminatory measures. Measures that breach this provision are not founded in reason or fact, but on caprice, prejudice, or personal preference. A breach of this standard requires the impairment caused by the discriminatory or unreasonable measure to be significant. Discriminatory treatment occurs where like persons are treated in a different manner in similar circumstances without reasonable or justifiable grounds, although there need not be discriminatory intent on part of the host state. In AES versus Hungary 2, the tribunal identified two elements to determine whether a state's acts are unreasonable or not. Firstly, the existence of a rational policy, and secondly, the reasonableness of the state's act relating to that policy. Reasonableness in this context requires an appropriate correlation between the state's public policy objective and the measure adopted to achieve it. Let us examine the prohibition against unlawful expropriation. The Energy Charter Treaty's prohibition against unlawful expropriation is contained in Article 13 and correlates with the well-known standard for expropriation under international law. It provides that expropriation is unlawful unless the following four requirements are satisfied. Firstly, it is done in the public interest. Secondly, it is not discriminatory. Thirdly, it is carried out under due process of law. And fourthly, it is accompanied by the payment of prompt, adequate and effective compensation. A classic example is that of Cardoso-Poulos versus Georgia. In this case, the tribunal found that Georgia had committed a classic case of direct expropriation by taking away the claimant's concession to distribute oil and gas in Georgia and transferring these rights to a state-owned entity. The tribunal also observed that Georgia failed in providing compensation or due process of law to the claimants. Article 13 of the Energy Charter Treaty also covers indirect expropriation, including in its definition a measure or measures having effect equivalent to nationalization or expropriation. Examples in this context include the UCOS cases, Electrabel, Charain and Mamid Oil. Let us examine the significance of the umbrella clause under the Energy Charter Treaty. Article 10(1) of the Energy Charter Treaty provides that each contracting party shall observe any obligations it has entered into with an investor or an investment of an investor of any other contracting party. Contracting parties may withhold their unconditional consent to international arbitration with respect to disputes arising out of this provision, as we have already mentioned. Let us examine the significance of umbrella clause under the Energy Charter Treaty. Article 10(1) of the Energy Charter Treaty provides that each contracting party shall observe any obligations it has entered into with an investor or an investment of an investor of any other contracting party. As we have already noted, contracting parties may withhold their unconditional consent to international arbitration with respect to disputes arising out of this provision. In Khan versus Mongolia, the tribunal observed that any violation of domestic foreign investment law would constitute a breach of umbrella clause under the Energy Charter Treaty. The tribunal found that Mongolia had breached a provision of its foreign investment law prohibiting unlawful expropriation and thereby breached the umbrella clause under the Energy Charter Treaty. In green tech energy systems, majority of the tribunal found that Italy had violated the umbrella clause under the Energy Charter Treaty. The majority interpreted the obligations referred to in ECT's umbrella clause as sufficiently broad to encompass not only contractual duties but also certain legislative and regulatory instruments that are specific enough to qualify as commitments to identifiable instruments or investors. Let us conclude our discussions. The substantive protections under the Energy Charter Treaty, from the cornerstone of its investment protection regime, seeking to balance investor confidence with the host state's right to regulate in the public interest. The guarantees of fair and equitable treatment and full protection and security have been interpreted by arbitral tribunals as safeguarding legitimate expectations and ensuring a stable, predictable legal framework. Similarly, the prohibition of unreasonable or discriminatory measures reinforces non-discrimination and transparency in the state conduct. The protection against unlawful expropriation upholds compensation-based limits on states' interference with property rights. The umbrella clause further elevates contractual or legal commitments to the level of treaty obligations, though its application remains contentious. Together, these standards illustrate both the strength and complexity of the Energy Charter Treaty's protective framework. Let's see what's coming up. The upcoming session will explore key arbitral awards under the Energy Charter Treaty, examining how tribunals have interpreted its substantive protections and jurisdictional provisions. Thank you.